My name's Alex Dolphin, and welcome back to another episode of Scienter. Today we're going to discuss the case Tellabs versus Makor issue and rights. This case was heard in the Supreme Court of the United States in 2007. Before we jump into the case, just to give a little bit of background to help contextualize what's going on here. So this is a securities class action lawsuit brought by private shareholders. So this is saying, these are private shareholders saying that a company, Tellabs, violated the securities laws by defrauding them when putting false or materially false statements into the market. Now, this type of action can be brought under Section 10b of the Securities Act or Rule 10b-5 that sets out a little bit more detail on this type of private action. So in one of these actions, the plaintiff will need to show that the company, executive officer, or its director made a material misstatement of fact or an omission of material fact when they had a duty to disclose. And they did so with Scienter, or a fancy word meaning that they did so intending to defraud someone. So that's the type of action that we're looking at here. So Tellabs was a publicly listed company. They sold fiber optic equipment, essentially. Now, in 2000, a few of their products began to experience slippage in demand. There's not as much demand for these products, and the revenue begins to slip. Well, in the face of that, the CEO of the company said, we're optimistic about future growth. We're optimistic about our revenue. We see strong demand for our products. So those statements were made to the public. Shortly thereafter, the company posts a loss in its 10Q. It also then makes some more statements saying, hey, we've seen a fall off in demand. We're not really seeing the type of demand like we used to. And so the market takes that pretty seriously. The stock price drops from $67 to around $15, so quite a significant loss. And so these plaintiffs in this class action are alleging, hey, you defrauded us when you said you had plenty of demand, you had growing revenue. And so we're going to sue you saying that you violated the federal securities laws when you tried to defraud us. And that's under 10b-5, like we talked about earlier. Now, like I said, under this type of action, you actually have to prove Scienter, right? So they have to plead in a way that would prove that there would be this intent to defraud the investors on behalf of the CEO when he made these statements. Now, this type of higher pleading standard was created by Congress in the PSLRA, the Private Securities Litigation Reform Act of 1995. Now, this act was passed with the intention of saying, hey, Congress said, we think private securities actions are good. We also think they're a little frivolous. And if you can get past the motion to dismiss in a litigation case, well, then it's a lot easier to get into discovery and you have a lot more settlement leverage against the defendant. And so they said, hey, we want to give a little bit more leverage back to these corporations in their defense against these hawkish plaintiff lawyers that are going out for a lot of money in these securities class action lawsuits. And so the standard that Congress created, the pleading standard, is higher than Rule 9, higher than Rule 8, of course, and Rule 9. And it creates its own standard. And under this, you have to plead, the plaintiff has to plead with particularity facts that create a strong inference of Scienter. So you can see particularity with facts and strong inference. Those are the two words that are doing some work and making this standard a little bit more stout than Rule 9, which is what these actions would have been pled under. So the district court says, hey, look, PSLRA, you got to plead, your complaint is insufficient, says that to the plaintiffs. You don't have enough facts to show that the CEO intended to defraud you when he made these statements about revenue and demand, and then it shortly thereafter fell off. You don't have the facts to prove with particularity. The Seventh Circuit on appeal reverses and says, well, we're going to create this standard. It's kind of mushy. Just could a reasonable person draw the inference of Scienter? And here it looks like there's enough facts that a reasonable person could draw the inference of Scienter. So then the defendants appeal to the Supreme Court. This is litigated, and there's quite a few parties that are interested, including the SEC, who jumps in on the oral argument. And basically, the court is left with, how are we going to articulate this particularity and strong inference standard for future parties in the court? And so they say, we don't like the Seventh Circuit's standard. Just a reasonable person could draw an inference. That's not quite strong enough. That doesn't really reflect Congress's intent in the PSLRA in trying to actually heighten that pleading standard. So they come up with their own standard. which is first, and this is Justice Ginsburg's, the opinion tracks very clearly what the pleading standard is. First, the court is going to accept all the factual allegations in the complaint as true. Now, this is pretty standard across Twombly, Iqbal, and regular pleading as well. Number two, the court is going to consider the complaint in its entirety along with other facts that a court might normally consider. Meaning, if there's sources that are available that the court could take judicial notice of, well, then the court could also consider that. But you're going to consider the complaint in its entirety. And then third, the court is going to determine whether there is a strong inference of Scienter. And they say in doing this, the court needs to find a cogent and compelling reason to find that Scienter. And the standard a little bit more clearly is only if a reasonable person would deem the inference of Scienter cogent and compelling at least as much as any opposing inference. So just to break that down is if there's two inferences and they're opposing and the one that shows innocence is higher than the one that shows guilt, well, then you should dismiss. Now, if the one that shows innocence and the one that shows guilt, those two inferences, those two facts, and they're just equal with each other, well, then you should allow it to proceed, right? Because it's at least as compelling. So it's kind of like this 50-50 thing. And if the plaintiffs can get enough facts that the judge finds it 50% of the way there, well, then the judge shouldn't dismiss. The judge should allow it to proceed. But if the judge can't make an inference based on the facts that, my inference based on these facts shows that, hey, innocence is a little bit more likely than guilt, well, I guess liability would be the better word. If innocence is a little bit more than liability, then the court's likely going to dismiss under this standard. At least that's what the court wants them to do. Now, the reason why they kind of pick this 50-50 threshold and the court doesn't go above that 50% is likely because of current concerns with the Seventh Amendment right to a jury trial, right? And so there's this thing in the Constitution that says that everyone's entitled to a jury trial as long as the action breaches a small monetary amount. Now, so the court is concerned, as the parties argued, that if the pleading standard was, higher than preponderance of the evidence, which would be the guilt standard, well, then this type of PSLRA and the strong inference would actually usurp that and take away a defendant's jury trial rights under the Constitution. So the court settles for this 50-50. And then at trial, it's going to be preponderance. So it seems like a little bit greater than 50 to find liability under the securities laws. Justice Scalia says he doesn't like this. He wants it to be, even stronger. He says Congress said strong inference. So that means it should be, if there's one fact and there's two inferences that can be drawn from it, the one that establishes guilt has got to be larger than the one that establishes innocence. Justice Stevens says he just would like to use the probable cause standard. He has no problem with the way that the court has, gone about and created this standard, but he just thinks that the probable cause standard would be better. And so you can see the court is kind of grappling with these fuzzy words, strong inference, particularity, that aren't clearly defined in the statute. And so they have to do so in a way that's nuanced, that reflects Congress's intent that to limit frivolous securities actions, but also doesn't usurp or conflict with the Seventh Amendment of the Constitution, thereby creating a constitutional problem. And so I think the court and Justice Ginsburg did a great job of threading the needle here and finding a standard that is, it might not be the most workable standard, but it reflects Congress's intent, and it also doesn't infringe on constitutional rights. So let me know if you think differently in the comments. I'd be curious to hear your perspective. Thanks so much for watching this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.